Hello everybody. Today I am going to discuss with you very important suit, that is partition suit. A partition suit is filed by a person who is deprived of his share in the suit property. That is a co-sharer. If when he is refused by the other co-sharer of his share in the property, either it may be immovable property or movable property, then that led him to file a suit for partition. Even a purchaser also can file a partition suit. The next question is whether notice is necessary before filing partition suit. So prior notice is not necessary, it is optional. But majority of the suits are filed without prior notices. Then the next question is what type of pleadings required in partition suit. So firstly, the plaintiff has to plead that he is a co-sharer in the property. Either the property may be self-acquired or joint family property or co-parcenary property, or under Muslim law it may be the persons. He should plead like tenants in common, and also the plaintiff has to plead that he is in a joint possession of the suit property. Apart from the same, as per 1983 Supreme Court ruling, genealogy has to be mentioned and it shall be mentioned. Then the next question is where the suit is to be filed. As per section 16, where the immovable property is situated, the suit is to be filed. And as per 19 and 20, in respect of suit is to file in respect of movable properties. Then the next question arises is what is the cause of action? Cause of action for this suit is the date on which he has been refused by the other co-sharers of his share in the suit property. Then next question arises what is the court fee that has to be paid? As per section 35(1), that is 35 subsection 1, if the plaintiff is not in possession, he has to pay under section 35 subsection 1. Whereas if he states that he is in joint possession of the suit property, he has to pay a fixed court fee as per section 35 subsection 2 of Karnataka Court Fees and Suit Violation Act. Then what in respect of agricultural property? Section 7 subsection 2 states that in respect of agricultural property partition is claimed, then it should be valued on the basis of assessment made. Then the next question arises whether is there any limitation for filing partition suit. So partition suit, there is no such limitation. It comes under category of under section 22 of, that is continuing cause of action. And even section, this article 113 is not applicable, but article 110 of the Limitation Act, if a person is excluded, go through that article where if a person is excluded, 12 years is the limitation for filing partition suit. Then question, what should be the prayer for this partition suit? The first prayer in this is a decree be passed dividing the property by metes and bounds. Second prayer would be if the defendant fails to partition the property, then the court commissioner be appointed to partition the property by metes and bounds. And third prayer, if necessary, that is if any sale has been made by one of the co-partners, then the said sale is not binding on the plaintiff, etc., is to be pleaded. Then comes after appearance of this defendant, he files a written statement. What are the defenses to this suit? The foremost is the first denial. Second is then the defendant can plead that the plaintiff has relinquished the share, or even the estoppel, acquiescence, and various other defenses as per the facts of the case. And also the defendant can plead adverse position as one of the defense. Then comes after the passing of the decree, or if the suit is dismissed, what is the remedy? If suppose the suit is decreed by the junior division court, then regular appeal has to be filed before the senior division court. Then thereafter regular second appeal is maintained before high court. Suppose if the suit is filed before senior division court and valuation of the share of the plaintiff is less than 10 lakhs, then the regular appeal is maintainable before district judge as a regular appeal, and then regular second appeal is maintainable before the high court. Then suppose if the valuation of the share of the plaintiff is more than 10 lakhs and the suit is filed before senior division court, then the regular first appeal is maintainable before the high court. What next after the decree of this partition? The partition decree is a preliminary decree. Again, a final decree proceedings is to be filed as per section 97 of the CPC. These final decree proceedings are filed as per Order 20, Rule 18 of the CPC. And after final decree proceedings, execution is to be filed. So whether after final decree proceeding appeal is maintainable? Yes, definitely. If the defendant has filed a regular appeal after preliminary decree, then he is able to file this appeal on this final decree proceeding as per section 97 of the CPC. So these are about the proceedings from the original suit to the regular appeal, regular first appeal, or regular second appeal. Then in the execution case, the decree is executable as per the just like Order 21, Rule 35, a suit for possession. Likewise, the share of the plaintiff is in this executable as per the provision, this as per Order 21 of the CPC. A regular execution petition has to be filed, and the possession granted, the decree granted in final decree proceeding, the exact share that has to be in the EP execution petition, the same is executable. So now I conclude my lecture on this partition suit, and I hereby inform you that I have already 160 notes, practical notes, for which are very much useful for advocates, and both criminal, civil and revenue and other topics, very important, regular useful for all the advocates, and each note carries ₹20, and around 160 notes are available. So the same you can pay on me on Google Pay or Phone Pay on my number, that is 94481 03272, and for details you can call me on 9740509272. Hence I conclude this lecture.